The Supreme Court has set 16th April for hearing of the substantive case of the election petition filed by Nana Akufo-Addo challenging the declaration of President Mahama as winner of the 2012 presidential election. In a bid to expedite the trial, witness evidence will be in the form of affidavits. The court will also require both petitioners and respondents to give oral evidence at the trial. The petitioners have up to the 7th of April to file affidavits of witnesses they intend to call, and the respondents have 5 days to respond. At the last sitting, both parties, that is the petitioners and the respondents, were given time to deliberate and agree on memorandum of issues to set the trial. They failed to come to a consensus. The outcome compelled the court at today's sitting to narrow down issues they will rely on during the trial to 2. The issues will be whether or not there were violations, malpractices, omissions and irregularities in the conduct of the 2012 presidential election held on the 7th and 8th of December, and whether or not the violations, irregularities, malpractices and omissions affected the outcome of the results of the election. With this, the court will decide whether the omissions and irregularities affected the results. The Electoral Commission also brought before the court 2 applications seeking from the petitioners further and better particulars in respect of the 28 polling stations where the petitioners allege voting took place, apart from the designated 26,002 polling stations. According to the counsel for the EC, Mr. James Kwashi-Aiden, the petitioners provided 22 polling stations instead of the 28. He asked the court to compel the petitioners to provide the remaining 6, as their failure will not allow the court to rely on the 22 they have provided. The court, however, dismissed his request on the grounds that the submission given by the counsel for the petitioners, Mr. Philip Addison, made it clear that they were going to rely on the 22 polling stations they have provided. The second application by the EC was to seek leave of the court to amend their amended response. Counsel for the EC argued that they omitted some vital responses that should have been included at the time of filing. The court, by a majority of 6-3, granted their request and gave the EC 3rd April, which is tomorrow, to effect their amendment. The court gave the mode of adoption of evidence as affidavit, ruling out requests by counsel for the petitioners to use audiovisuals and PowerPoint presentations, and the respondents' call to allow in any other witness that wants to testify to what they saw and know. However, the court went on to rule that witnesses for both parties in the case will have to give evidence in the form of affidavit, and when necessary, application for cross-examination can be made and determined on merit. This, the presiding judge, Justice William Atuguba, said is to expedite the trial. Also, the parties themselves, that is the petitioners, Nana Akufo-Addo, Mahamudu Bawumia and Jake Obechebi Lamte, the respondents, President John Mahama, the EC and the NDC, are entitled to give oral evidence. Counsel for both the NDC and the NPP later spoke to the media.
After evidence has been led to establish whether or not there were violations, omissions, malpractices, and irregularities in the trial, in the election, then it will mean that the court will have to also decide the critical question whether these violations, omissions, irregularities, or malpractices affected the result. They also did indicate that there were 28 locations where the elections took place outside the known polling stations, designated in the country. Again, today they did concede that they can talk only about 22. They can't talk about 6 others. So those 6 others, they can't lead evidence to that.
The Electoral Commission brought a 2-pronged application. One was seeking further and better particulars in respect of some 28 locations that were not part of the statutory list of over 26,000 polling stations that were used for the elections in the 2013 elections. We took the position that we had already provided the material. they took the position that it was shot by some 6 polling stations, and therefore they had brought the application for the court to compel us to bring those particulars. Of course, there was no merit in that, because the rules that come to play is that where you are asked to bring a certain number of pieces of evidence and you have been able to bring a limited number, you are bound to give evidence in respect of that. The court took the position that by bringing the application, they were compelling the court to remake an order that they had already made. So unanimously,